not often that I come to a seminar such as this and actually have another speaker mention IP. So I'm absolutely thrilled that David did mention IP as part of his presentation, because I'm hoping that after you've listened to me as well, it's going to be top of mind and you're all going to go back to your businesses and start thinking about what IP you have in your business and how best you can extract value out of it. So we'll get started. Why would you think about intellectual property in your business? And I'm going to give you some examples later in this presentation. But the sale of a business involves numerous legal considerations, and David gave a really good overview of that earlier in his presentation. But a key issue often for buyers and sellers, in my experience, and often lenders as well, is whether the business has adequate IP protection. IP is usually one of those factors that's used to determine the value of a business. And its value, as a proportion of a business's value, is increasing, and it often exceeds the value of other assets like buildings and plant and machinery. And I see on many occasions inadequate IP protection or a lack of clarification as to what the IP assets of a business has can derail the business sale. And David actually gave you an example of that in one of his case studies. So I urge you all to think about what IP you have in your business, because it does need to be recognised in terms of what you are selling if you are looking to sell your business. Each business is different, so it's therefore essential that you understand what IP you have, you've identified it properly, you've scrutinised it, and you've properly valued it as part of the overall sale transaction. But I would also say, don't just do it when you're thinking about selling your business, do it right from the outset, whether you're at the stage of setting up your business, whether you're halfway through the development of your business. Think about it right at that stage and make sure you have it clearly articulated so that when you get to a stage of seeking investment or looking to sell, you can have a good, comprehensive discussion about what your IP assets are. So, what is intellectual property? You've probably heard this term many times, and it's often misquoted and misunderstood. It is an umbrella term which refers to the ownership of tangible or intangible result of creative thinking or intellectual activity. It's often thought of in terms of, and again you probably would have heard some of these terms, the innovative idea behind new technologies. And those technologies are increasing extensively on a daily basis. AI, VR, apps that can do all sorts of things. You think of it in terms of products and processes in your business, the goodwill and brands. The law recognises IP as a property right which can be sold, licensed, exchanged, give away, trespassed upon, just like bricks and mortar property. So if you think of it in those terms, what you can do with your house, you can also do with your intellectual property assets. The key thing though, and most people say to me when I first encounter them, I don't really think I've got any intellectual property assets. And I would beg to differ. I think most businesses have an IP assets, it's just that it's not well recognised. So what IP rights exist? An IP right can be a registered right or an unregistered right. And as the name suggests, in order to get a registered right, you need to apply to an intellectual property office in the country where you're trying to seek that right. You pay money for it, and it gives the owner a monopoly right for a period of time. And that period of time varies from each IP right. On the other hand, unregistered rights are created automatically. For those of you, for those of you who are doodling or perhaps taking notes throughout this seminar, you will automatically be creating a copyright work. So that's the sort of thing that comes into existence automatically, and you can claim copyright in that. You don't have to pay for them. They are usually for limited terms. And because there's no register of an unregistered right, it's really important that the business actually acknowledges what they are, they document them, and they take steps to treat them appropriately in their business. As the name suggests, trade secrets and confidential information by their very nature either need to be kept confidential or secret in order to maintain the right that is attributed to what you are claiming. And that involves actually documenting it in particular ways and following particular protocols to make sure that you retain its secrecy or the fact that it is confidential in your business. Otherwise, once it's in the public domain, you've lost the ability to add and extract value from that in a sales situation. So what could IP rights look like in your business? And I've put some examples on there. They could be patents, they could be designs, they could be copyright, they could be trademarks, they could be trade secrets, they could be domains, just as an example. So we're all familiar with words and logos, and the famous one is Coca-Cola. But it can be things like trade secrets, the Kentucky Fried Chicken batter recipe, can even be the Coca-Cola recipe. You can have shapes in the form of products like the Coca-Cola bottle, or even the shape of the grain snack food. The tennis ball, the IP that sits around that, does anyone want to have a guess as to what that might be? Jeff, you've probably heard this example, so you can't answer. It's actually the smell of grass. So Dunlop, they decided that their IP, they had a standard product, how are they going to differentiate themselves in the marketplace? So they infused the tennis balls with the smell of freshly mowed grass, and so when you opened up the canister of the balls, you were given this smell as a point of differentiator. I was actually only reading yesterday that in the US, they've granted rights to Play-Doh, who produces modelling clay, for the smell of that Play-Doh. Now, those of you that have ever experienced that product, it is a sickly sweet vanilla smell that's been infused with cherry, and it has a wheat-based foundation, and that's what they've registered as an identifier of their product. So what we're seeing is that IP rights are pushing boundaries. And this is where it often comes unstuck in a business, because the boundaries are constantly being pushed. That means if you're not thinking about IP in your business, there's opportunities that you may be losing. In the area that I particularly work in, trademarks, those boundaries are moving incredibly far. And examples are, we're looking at registering animation, we're looking at registering holographs, we're looking at registering retail outlets. Apple recently in the US and Europe obtained registration for the layout of their store, and their argument there was anyone who goes into an Apple store, and I'm sure many of you have if you've been travelling overseas, they're saying that customers would recognise the layout and they'd know it's an Apple store because of the way it's been set up, and they don't need to have any Apple branding on it, it's the layout. And so they've actually taken steps to register that particular layout. And you can sort of see in New Zealand we have businesses that operate in the retail space that have a particular look and feel and a setup, and if they recognise that, they could be looking at taking steps to protect that by way of IP protection. So it's an ever-moving field in terms of IP protection, and I guess the one thing I would encourage you all to do is constantly be thinking about, do I have anything that is protectable here, and if I do I want to spend the money to do it? But also these are some other examples in terms of IP that may come about in your business, possibly. The chair is an interesting example, and I put it up there specifically because IP rights often work together. They're not mutually exclusive, and one particular product will have multiple IP rights often. So in the case of the chair, just to give you an example of how they would work, there would be copyright in the original drawings of the chair, the photographs and the prototypes. There could be patents for the back ergonomic functionality, the height and adjustment mechanisms, the movability of it. Designs could protect the look of the chair, because that chair looks completely different to the chairs that you're all sitting on, and would look completely different to various other chairs that are actually on the market. So the fact that it looks different enables it to be registered by a design, if in fact that's where you want to spend your resources. There'd also be a trademark, because the chair would have a name or some sort of logo or some way that a consumer would identify with that product. So again, there would be a trademark for that. There could also be trade secrets resulting from testing results, pricing information, customer targets for the chair, marketing information. So you can see from one very ordinary chair, as an example, how multiple IP rights can actually play out in your business. But not all IP rights, as I've explained, are the same. They come in different forms. They cover different aspects of an idea or an innovation. They can be registered or unregistered. They have different scopes of rights. They are treated differently by various IP offices around the world. They last for different terms, and they differ in costs if you're seeking registered rights. So same, but different, but understanding what it is that you have in your business as an IP asset and getting some early advice as to how to recognise that, I would encourage. So when you're thinking about selling your business, if you accept that most businesses have an IP asset of one form or another, then these are the things that I would encourage to be thought about as part of the sale process. Because both, as you've heard before from other speakers, both a buyer and a seller of a business must understand what is being bought and sold as part of that transaction. And that sounds easy, but often that takes a lot of time and effort to delve into and understand exactly what is being bought and sold. So in terms of IP identification, in my experience, the IP assets of a business are often overlooked. They're undocumented, they're unknown to the business, and principally that is because what would constitute an IP asset hasn't been recognised. If you've got IP rights that can be registered, I would encourage you to think about registering them, because then you've got concrete evidence in terms of your ownership, the term, and that can add value to the business in terms of the sale process. Documenting it, we would encourage that IP rights be documented in schedules for ready access and mapping against products and services that are offered by the business. So from a purchaser's point of view, you're in the business of providing manufacturing furniture, as an example. So different styles of chair within your range and the associated IP rights that go with that. Very clear for a purchaser to say what you own, where there are gaps, easily identifiable and easily able to be included in any sale transaction documentation. Often employment or contractor contracts do not include IP clauses, and we're seeing this more and more. And we would encourage you to do that now. And if you're dealing with contractors, or you have IP, if you have employees who deal with IP in your business or would be creating IP works, actually make sure that you own them as part of that whole process. Because if they're not owned by the business at the time of sale, then they won't pass to the new owner, and again, value may not be extracted as part of the sale process because they haven't been recognised. We also see on a regular basis business owners protecting IP in their own name and file for rights in their own name because they're doing it themselves, rather than in the name of the business. If it is actually the business that is using the intellectual property as part of the business operation, then the intellectual property should be held by the company. So then it can transfer with the company and there's no issues in terms of ownership as part of the sale transaction or post-sale. We also see a number of domain name registrations in the names of IT people within an organisation, because that falls usually within their area of responsibility, and it's a very easy system to register a domain name, and it says your name as part of the form, so logically people put in their own name instead of thinking, actually I'm applying for this on behalf of the company. And so then they end up owning the domain name. They may leave the business. You then got to try and track them down as part of a sale process to get that transferred over, if in fact you can even find them. But even before that, there can be issues, because if they leave it, domain names generally are renewed on an annual basis, and if the renewal reminder is going to the IT employee who has left, then no one's usually going to be looking at that box, no one's going to action the renewal, and the whole thing falls over. And that can be a disaster, as I'm sure you can appreciate. Another thing to consider is third-party IP rights. Do you have any, like software licenses? Have they been properly licensed? Does the business know what risks surround the withdrawal of those licenses? Would a change in ownership render a license inoperable? Will selling the products or services of the business post-sale infringe the IP rights of others? What advice or searches have been conducted to give a purchaser peace of mind that this issue has been considered? These are all questions that need to be asked during a due diligence process. In terms of valuing IP, identifying and valuing it as used by a business in advance of a sale will have a number of positive effects. It does reduce the chance that an issue will be discovered during the due diligence that could cause the sale to derail, and that does happen. Peace of mind will be derived by the purchaser, who sees that valuable intangible assets of the business have been protected as comprehensively as possible, and key processes have been captured in writing and protected wherever possible. By properly valuing the IP assets of a business, the sale price can even be justified or increased, and we've seen that as part of due diligence occurring. We've been brought into the process, and we've been asking questions. What about this software? What about this process? And suddenly, the business actually being sold has realised that they have a lot more assets to bring to the sale table than they realised previously, and that's actually increased the sale price. Things like confidential processes and methodologies used by employees of a business are sometimes also overlooked, as well as licensed IP, which, although not owned by the business, can be critical to the ongoing continuity of the business and can be very valuable, particularly if you've got the exclusive license for something in a particular country or territory. So from an IP perspective, when you're looking at the sale process, I know you've had David give you tips and tricks in terms of the legal perspective. So I'm going to concentrate more on the IP perspective and bring in some points there. So preparing a confidential selling document outlining what it is that you're selling, and I'm sorry to reiterate the point, but this is where the identification of your intellectual property, what is it that you're selling, how can you prove that you own it, and all the associated considerations that go with that really do need to be thought about pre-contract, because this will help you develop what deal points you're going to raise in the negotiation. And at that stage, if it becomes apparent that you actually haven't protected your IP as well as you could, then that's the stage to actually put in place some steps to try and do that. Identify what copyright works you have, identify if you have any trade secrets and how you're managing the secrecy associated with those trade secrets. What confidential information do you have, like your pricing information, your marketing plans, how are you keeping those confidential within your business? Some IP rights you would be able to file at that stage, like your trademarks, possibly some domain names, but other IP rights like patents and designs, they need to be filed before there is any public disclosure of the invention or the shape of the product that you're trying to protect. So if you've put them on the market, if you've commercialised those IP rights in any way, then the opportunity for you to seek protection around them is lost. So it's not a matter of being able to backfill at that stage, you just can't do it for patents and designs, which goes back to my earlier point of when you're setting up a business or you're halfway through the evolution of your business, you should still be looking at what IP rights you have, because they'll be created throughout the life of your business. timings can be important. And you've heard some commentary about getting external advice, and again, I would urge you to think about talking to a patent attorney if you do have IP assets and they are part of the sale process, because timings can be important from a transactional point of view and also a documentary point of view. I was just working with a client the other day, and he had sold his business, and then he changed the name of his company, and he's off doing something else. And I've now been brought into the process, and I need to record the transfers in China. Now, the problem that I've got is that the business has changed its name, and so the parties originally to the contract, I can't prove by the company, so I can't get a certificate of incorporation for the original company name because it shows that they've changed their name. Now in China, what I'm going to have to do in that particular instance is record the change of name. Even though the new company isn't party to this transaction, I have to record the change of name against 6 Chinese trademarks first before I can record the assignment, and that's just added another US $10,000 to the recordal of that transfer, which was already at $20,000 US. So the very fact that I hadn't been brought early into the process and knew about it and said I need to get this all filed before you change your company name has just added significantly to the costs. And of course now there's a bit of a discussion as to who's going to wear those costs between the buyer and the seller. So timings can be really critically important. At the contract stage, all business transfers require transaction structuring and contract customisation. You heard that from David, it's not a one-size-fits-all. You need to be thinking very clearly about what the contract is going to look like. But in the IP area alone, the transaction will need to consider the use of a confidential information agreement or confidentiality provisions in the agreement, any risks to the IP assets like warranties, indemnities, personal guarantees or other security arrangements that have been given by the seller, the tax implications of any apportionment in the contract of the sale price between the various assets being sold. What I mean by that is that different values will be attributed to the different IP rights of trademarks and copyright and patents, and that needs to be well thought through in conjunction with a tax advisor. There needs to be a review of consents or other license arrangements the seller has entered into to make sure that there's no conditions attributable to them that may be activated upon a sale. Another thing to think about, we've had some discussion today about the seller remaining in the business. In my experience, often they do move outside of the business, and in that scenario, do you need to think about any non-competition restraints on the seller in terms of things like hiring former employees, starting a similar business, soliciting customers of that business, and using the IP that they probably think they have some ownership over because they created it in the first instance and may not realise that when they've sold it, they can't actually continue to use it. In terms of post-contract stage, need to take steps. So you've got your sale and purchase documentation, you've got the money in the bag, and you think, whew, done it, the deal's done. But there's usually a lot of steps that need to be taken, particularly in the IP space, post-sale. I was just mentioning briefly about recording the transfers in China. They can take a lot of time to do. They need a lot of documentation around them. And if you don't positively apply to the various IP offices where the IP rights exist to change the ownership, they'll remain in the former owner's name, i.e. the seller. So there's a lot of post-contract work that needs to be done around IP assets, and that does, in some instances, involve quite a bit of cost too. So that's another consideration in terms of who's going to pay as part of the deal, the timings of that, making sure that the seller is available to sign ongoing documentation if it hasn't all been tidied up as part of the sale documentation, which in my experience it very, very often isn't thought about. Because if we don't tidy up all the details, This can often lead to missed deadlines in terms of renewal. I think I mentioned to you that IP rights have specific terms and they need to be renewed. If you're not listed as the owner, if they've sort of fallen between a gap in terms of advisors, then renewal deadlines would be missed. That means you could lose those rights that you've just bought. You might lose valuable documentation proving that you own them because certificates of registration will be sent to the wrong parties. So it's really important to think about all the post-contract stages that are attributed to your IP to make sure that they all don't fall over. Because often, if you're looking for enforcing rights, so in litigation, if you aren't listed as the owner, then there's a delay in being able to enforce any rights that you might have, because we would need to first update all the registers to prove that you were the owner before we can then initiate litigation action for you. And the timeframes are not quick for some of these things. In New Zealand, we operate fairly promptly, so you can get a change in ownership recorded in about 4 weeks. At the other end of the scale, if you were dealing in Nigeria, for example, you'd be at 25 years. Malaysia, and most people think of Malaysia as a reasonably industrial country pretty onto it. It can take 7 years to record, update details in those countries. So timings are quite critical, understanding what you need to do and actually getting onto it. Post-contract, as part of the due diligence process, there may have been an identification of gaps in the IP protection, and that's a good time where possible to fill those gaps, so that again you're extracting the most value out of the processes and the IP assets that you've bought, and ensure that there is implementation of best practice for IP protection, record keeping, IP management after purchase. Issues can arise and do arise from a lack of alignment and integration between the business's management, commercial, technological and legal processes and systems of the buyer and the seller. And it takes us back to full circle in terms of having those early conversations at the pre-contract stage. So in summary, business owners, I would encourage to understand, recognise, document, and think about the value of those IP assets that you have in your business as part of any sale that you may be contemplating. I'd also encourage you to think about them now, if you haven't, and align them with your overall business strategy so that it's an ongoing business as usual process. Because as I mentioned, it can be very difficult to fill gaps in your IP protection years down the track. There's quite a lot of restrictions on what you can do. So following a robust process of looking after your IP assets of a business throughout the life cycle of it prevents problems arising when selling a business. Thank you.
Terrific. Does anyone have any questions for Corinne regarding IP and the protection of your IP? Yeah, go ahead.
Hi, Kai, how are you?
Query about IP in terms of recipes for manufacturers and things like that, using raw materials as well. Would that be something that is covered under the IP and are there registrations available for that sort of thing?
There's no specific, patent protection could protect some of the formulations. So you can protect, as an example, pharmaceutical compositions as part of a patent process. So it would need to be new and novel at the date of filing. So new and novel over what is already known in the industry. So one of the challenges for a lot of businesses in terms of formulations is that there's really nothing unusual in terms of their formulation. But if there's a secret ingredient or a...
We've got a product that we sell is nowhere globally. It is a radio type of product.
Right, so that would be, so before that's commercialised, that would be a perfect time to be talking.
Any other questions? Corinne, can one new innovation have... Oh, this is really quite loud, isn't it? I'm going to push that way down. Can a single innovation have multiple IP rights?
Yes, it can. So the example that I was giving you of the chair, can have, as I was explaining, can have the copyright, can have the patent, can have the design, can have the trademark, and as well as trade secrets and domain names and various other rights. And the beauty about thinking of multiple IP rights, I'll use products as an example though, it's more difficult for services, but if we just stick to the product example, because IP rights, I think I mentioned to you, have different terms. So your copyright is generally speaking going to last for 50 years. That may extend under CTPPP to 70 years. Patents last for 20 years. Designs last for 15 years. Trademarks last forever. So you can sort of see, if you've got one product with a suite of different IP rights, how you can leverage the investment that you've made in protecting and recognising your IP over the life cycle of that share, assuming it lasts for as long as that and is integral to your business. Because as various IP rights drop away, the most enduring one that you'll have will be your trademark. So if you get a distinctive trademark that you've registered at the outset, as an example, that will give you the longevity, and you'll have at least that, even if this is a product that's been around in your business for, say, 50 years. So, yeah.